5:30 today. His is a reading.
Can you make sure your cell phones are all full of?
Oh, shoot.
Please rise for the pledge. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to Texas, one state, under God, one and indivisible.
County Commissioners Court is now in progress.
January the 29th, 2026, 9 p.m. Commissioners Court of Jim Wells County is now in session. Okay. Line item number 3, public testimony. Anybody not on the agenda may appear before the court at this time. Any?
Morning, sir.
Morning.
Good morning, Commissioners. Joseph Scott Baker. I'm a sheriff of Jim Wells County. Commissioners, for the record, I want to provide a brief informational update in good faith regarding the Sheriff's Office operations that have been discussed in recent meetings. I have submitted memorandum addressing certain things, including statutory and court mandated duties affecting the Sheriff's Office operations, along with transport costs and comparisons. These documents have already been filed with the clerk's office. So I also want to say these documents are informational only. I'm not requesting any kind of action to be taken. The purpose of this comment is not to respond to criticism. No action requested on that. My intent is simply to ensure that the public record is corrected and has accurate information without any kind of speculation or conjecture. So the first document I'm going to read, and you all have had been given copies of that. Clarification of abatement enforcement authority process and expectations regarding discussions held January 9th, 2026. This response is submitted to correct several factual, legal, and procedural misunderstandings that were expressed in the January 9th, 2026 Commissioners Court regarding abatement enforcement. These clarifications are grounded in the Jim Wells County abatement procedures adopted by Commissioners Court May 13th, 2024, pursuant to Chapter 343 of the Texas Health and Safety Code. This is not a response to criticism. Again, this is a necessary clarification of authority, responsibility, and operational limits as adopted by this court. The Sheriff's Office will not accept responsibility for outcomes that exist or extend, trying to extend its legal authority or the resources and procedures that are established by this court. Abatement enforcement activity and lack of production claims. Statements were made characterizing abatement enforcement as unproductive, based primarily on the number of criminal complaints being filed. This characterization is inaccurate and it's false. Under the county's adopted procedures, nuisance abatement is a civil administrative process, not a prosecution-driven function. This is what you adopted. This order assigns intake, investigation, determination, notice, and compliance monitoring as an administrator, not a law enforcement patrol activity. And you can look at orders 5.3 through 5.9 in that adoption. Abatement enforcement is designed to achieve voluntary compliance following these notices, not to generate criminal filings. When a nuisance is corrected with without court action, enforcement has succeeded exactly as the abatement ordinance intends. Using criminal case totals as a performance metric directly contradicts the structure and the purpose of the court's adopted process. Secondly, civil versus criminal authority. Multiple comments reflect the belief that abatement enforcement should function similarly to traffic enforcement with proactive patrols and routine citations. That brief is legally unsound. The adopted order requires written complaints, administrative inspections, and determinations. It requires a notice to abate. Mandatory compliance periods include 31-day timelines and hearing opportunities, and Commissioners Court's authorization before county-initiated abatement. That's in sections 5 through 9. Nothing in the order authorizes deputies to issue citations, seize property, or compel abatement, absent compliance within these procedures. Abatement enforcement is procedural by design, not patrol-driven. This is what you adopted. Enforcement cannot be driven by frustration. It must follow the law as adopted. Point 3, authority, staffing, structural misunderstandings. Discussion occurred during regarding the reassignment of abatement responsibilities, evaluation of effectiveness, and potential placement of enforcement authority under other offices. For clarity, that's fine with me. The sheriff does not create or appoint abatement positions. The sheriff does not supervise non-sheriff personnel. The sheriff does not define or expand the legal scope of abatement authority. That's well within the court's purview. The adopted order places responsibility for determination, notice, hearing, cost estimates, and referrals squarely within the administrative framework established by this Commissioners Court, including the hearing examiner process and the court-ordered abatement decisions. That's in section 7 through 10. Effectiveness cannot be measured without first defining the authority, the tools, and the process. Critiquing the outcomes without acknowledging these limits is misplaced. Point 4, illegal dumping. It is a real problem, but it's been poorly framed. I'm not going to argue that. Illegal dumping is a legitimate countywide issue. That fact is I'm not disputing. What is disputed is the implication that the persistence of illegal dumping is a result by inaction from the sheriff's office. The order narrowly defines what constitutes public nuisance, including time thresholds, visibility requirements, and location constraints. And this is part 3 of the public nuisance definition. Not every unsightly condition, abandoned vehicle or roadside object qualifies as a nuisance under the adopted definitions that this court has enforced. And enforcement must meet the criteria before action can be taken. Existing enforcement outcomes beyond this definition and procedures adopted by this court is unrealistic. 5, parking enforcement and ordinance gaps. The discussion also included calls for enforcing a 72-hour parking restriction. Currently, as it stands, the adopted nuisance abatement procedure does not establish a 72-hour parking ordinance. They do not grant deputies the authority or enforcement ability to enforce that. Abatement is a separate absent a separately adopted ordinance. No such authority for the sheriff's office exists to enforce that. If you want that, you have to adopt another ordinance or an addendum to it. Deputies, we cannot invent authority in the field. Okay, we just can't do it. Policy creation is a legislative function, this court. Enforcement then follows that policy, but not the reverse. Now, that being said, we are helping the safety department with abatement issues. We're packaging everything up. We do the investigation. We will help with all of that. I'm not saying we're not going to help with that. The enforcement part of it is the issue of how we enforce it. Claims of no response or non-communication. Assertions were made that the abatement complaints received no response. These were made without reference to dates, documentation, written complaints, or escalation through established administrative channels. I have not received any complaints myself. Everybody has my phone number. If you do, all you have to do is pick up the phone. The order requires, but I will say this, the order requires written complaints. It requires administrative review under this adopted process. Public statements are not a substitute for a documented notice, such as a written complaint or an administrative review. The path forward. The Sheriff's Office remains willing to participate in any kind of structured, good faith discussion regarding abatement enforcement, provided that discussion is grounded in clearly adopted ordinance authority, define the statutory authority, realistic expectations of what we can do, and appropriate tools and funding to allow us to do that. And I would like to also formal communication protocols. Enforcement will always follow the law as written and adopted. Expectation must align with the authority. And authority must be supported by policy and resources. Frustration does not expand our legal power as far as the Sheriff's Office is concerned.
Excuse me, is it gonna last much longer?
I've got one more to read.
Because you're already 10 minutes.
I'm 10 minutes
Yeah,
already.
You know, if the court allows you to go keep on, you know, we're okay. You know,
It's I'll leave that up to you. Do you want me to stop here?
the what?
I'll leave that up to you. Do you want me to stop here?
No, we could ask the court if they allow another 5 minutes or whatever. The court, you know, is that pretty much?
It's, the limit is, we have a 3-minute limit, but it's subject to extension by the court. But if these materials have been filed, you can read them at your leisure after the meeting.
Yeah, okay, I'll ask the court if we allow another 3-4 minutes.
I'm fine with that.
Okay, no problem, okay. You can proceed, sir. I just trying to follow the rules, you know.
No problem.
you know,
I want
it's,
to follow the rules
It's
as
usually
well.
just 3 minutes. You're at 12 minutes. Anyway, go ahead.
All right, time noted. Okay, I'll try to speed this last one up. The second thing that I wanted to address was the Sheriff's Office informational notice of statutory and court mandated duties affecting the Sheriff's Office expenditures. For filing the official, hang on, I'll just skip this and go to it. So I did send you some information also, and so this is to provide at the onset of the fiscal year. This is for informational purposes to document the Sheriff's Office expenditures that are mandated by Texas law and court order, and therefore this is not subject to discretionary cost controls at times. Under the Texas Constitution and applicable statutes, the sheriff serves as the county's chief law enforcement officer and is legally responsible for the custody, transport, and safekeeping of inmates, as well as the execution of lawful court orders. These duties must be performed regardless of timing, volume, or budgetary constraints. Pursuant to the Texas Code of Criminal Procedure, the Texas Health and Safety Code, and lawful orders of the county and district courts, the Sheriff's Office is required to carry out non-discretionary functions that materially affect expenditures. And I think it's important for the court to know this. Mental health commitments and transports, including emergency detentions and court-ordered evaluations that are time-sensitive and cannot be delayed or declined. I don't have an option to decline these. Juvenile detention transports required by the court order, juvenile justice statutes that involve extended travel all the way to East Texas, to North Texas, and it requires dedicated staffing. I don't have an option for these. court-ordered mandate transports, including transports outside the county, transports to court. I don't have an option. These are court-ordered mandates that are put on me. I can't deny them. Out-of-county inmate housing, this is required to comply with jail capacity limits, inmate classification standards, and medical needs for safety requirements. I don't have an option. I can't decline these. And then I'll skip part of this. You have it already. I did a cost comparison analysis on the transportation versus contract transport. It's very clear. With every contracted transport, we save over $650 per transport as opposed to using our own staff. Our staff has done almost half of the transports in January, and about a little over half have been done by contract. So the idea that we are not doing any transports with our staff, we do when we can. What I can't do is violate the law and to complete those transports. I just want to make the court aware of what the sheriff's office faces and honestly the county faces. It's not just me, it's the county that is responsible for all of these things. That's all I have. Thank you.
Okay, appreciate it. Is there anybody else? Not being Eddie, we'll proceed to line item number 4, the grant. Discuss, review bid tabulations, engineer recommendation letter, and consider awarding a construction contract for the related water line replacement project being implemented under the Texas Department of Agricultural, Texas CDBG contract number CDV 230313. Mr. Garcia?
Good morning. For the record, I'm Raul Garcia, the project engineer on this particular project. If I may, I have a couple of handouts. This project opened bids to the last Commissioner's Court last week. It is a water line replacement project in the Rancho Alegre area. If you look at the site map I gave you, it replaces a 2-inch line on Rosario and a 2-inch line on Herrera and replaces it with an 8-inch line, tying it into the 12-inch line on McMaster's, the 6-inch line on Beam Station, and then tying into the lines on Corina and on Carmen. It also brings in fire protection. We received 5 bids. And you've got the bid tabulations in that second handout I gave you. The low bid was Tom Oaks Construction at $356,500. The budget for the project was $400,200. I do recommend that the contract be awarded to the low bidder, being Tom Oaks Construction. I do believe I saw that Lucy is on the phone in case you have any grant questions.
Is there any questions? I don't have any.
This will disconnect the existing services and reconnect it to the bigger line. This area will now have enhanced pressure because what we did on McMaster's and on 5154 enhanced the pressure. Now we're getting rid of all the small lines and this whole area will now be enhanced.
You have enough pressure.
Now we do, yes, sir. And this eventually will go into the expressway also. I think it's already been taken to the expressway.
Let me ask you, the house lines that tie into the 2-inch, are those just gonna be replaced where they connect to the 2-inch, or they're gonna be replaced all the way to the boundary of the fence
We're just
line?
reconnecting. Reconnecting the existing services. We're also being careful with the sewer service lines. We're putting casing as per TCEQ.
Mr. Garcia, Mr. Rivera, can I ask a question to the bidder? To the bidder?
Oh, the bidder.
Yeah.
Oh, the bidder, I'm sorry.
Is that okay if I ask a question? Mr. Oaks, The grant is $400,000? Yes, sir. And the bid was $356,500. Do you foresee any changes that that would increase the cost?
No, there's not any changes in what we did,
Excuse me. We have not awarded the contract yet. You know, so we award the contract, then I guess questions could be more appropriate. Thank you.
Ask the question because.
Okay, the bids,
There were specs that were bid on, so
Yeah.
that's what.
it's already, the price is already out. Okay, it's $400,000 was a grant, but he bid $356,500. And I'm just asking whether he would foresee any changes that would increase the cost, like change orders, you know?
If I may on
that
that,
you
now,
could be-
one thing we're gonna have to do is we wanna spend every penny because we don't wanna send anything back. We've had some discussions with the city. The original grant had it up to Carmen. But that line is a 2-inch line, but there's a 6-inch line about 300 feet from there. Once we have everything established, we may be able to amend the contract to connect it and have a complete bigger loop. There's also other items that may come up, you never know. These areas have lines that you don't, and when we did McMaster's, we found lines out there that nobody knew they were there. I don't foresee
so we
anything
can
that's gonna ask you to come up. We have everything bid already, and then we just take it from there.
Can we proceed with the recommendation and then
Yes, sir.
we can go from there?
You got it, yes, sir.
So your recommendation was to award it?
The Tom Oaks Construction at the low bid.
Okay, so you established that already, right?
Yes, sir.
That's who it's going to.
And you have the
You know,
5
I
bids.
just hadn't heard it from you.
Yes, sir. It's on the letter. Yes, sir.
Okay, it's here, but you know, we hadn't.
Tom
actually-
Oaks Construction for a bid.
Anyway,
of-
now you can proceed with your questions.
I make a motion to award contract with Tom Oaks.
Second.
Okay, there's a motion and a second. All in favor indicate by saying aye.
Aye.
All opposed, same sign.
Mr. Garcia, will those changes be brought up to the Commissioner's Court?
What's that?
Those changes be brought up to Commissioner's
Yes,
Court?
sir.
if there's any?
Especially, we're gonna have to do an amendment. That
Okay,
is,
okay.
and there will be, again, I'm assuming there will be a change order because we want to spend every penny that the state has.
I would like to advise you, sir, that the word spend is not really appropriate here. We like to invest. Thank you.
Thank you. Thank you. You'll have a good day.
Thank you.
Thank you.
My kids spend. We invest here. Thank you.
Anything else?
You had questions? for me?
Congratulations, Mr. Oaks. Is it? That was it?
Okay. No, okay, is there any more questions, commissioners?
I'm good.
Is that it? Can we go back to the open session? Can we go back to the open comments?
Yeah, we can go back,
Is it, that was it?
we can go back to public speaking, if that's what you
Yeah,
want.
just real quick, guys, we're gonna be in Fremont today, Mr. Guerra, Mr. Perez, everybody here. At 1 o'clock, we're gonna serve, meals, not meals, but a package for the veterans. So if anybody's out there in that area, we're welcome to come by and participate there. It's at 1 o'clock at the Laughlin Building. Thank you, Mr. Garcia.
Okey dokey, line item number 5, motion to adjourn.
Motion to adjourn?
Second.
There's a motion and a second. All in favor indicate by saying aye.
Aye.
All
Aye.
opposed, same sign. Thank you.